May it please your lordship.
Yes, please.
My lord, I beg to mention item number 5 and 6 of motion, my lord. Inadvertently, some mistakes have cropped in. I want to withdraw both the writ petition and file it afresh, so my liberty may be
You
granted.
take down Mr. J. Patwari, learned counsel appearing for the writ petition submits that there is some inadvertent mistake in these writ petitions which require rectification. So therefore, he seeks leave of this court to withdraw the same with liberty to file afresh. The prayer is not opposed by the respondent's counsel. In view of the above, this writ petition is disposed of on withdrawal with liberty as prayed for. Same order in item 6 also.
Well, I have a similar prayer with regard to item number 8, madam.
Item number 8.
8, madam, yes.
Acha. Mr. M.R. Adhikari, baki same hoga. Yes.
May it please your lordship. Lordship, we have filed a repetition in the morning. This is regarding disqualification of candidates in SSC lordship for height and chest who were qualified earlier lordship. May be taken up at 2 lordship.
Sorry, today there is another bench. You mentioned it in the other court. You've seen the list, there is a division bench at 2. Not possible.
Lordship, at the end of the motion, lordship.
You mentioned it before the other bench. There is a division bench. This court is rising and division bench. It's not possible unless the bench is constituted, which cannot be done now.
May it please your lordship, with the consent of other side, my lord, I beg to mention item 16, my lord.
Yes.
This matter may kindly be taken up after vacation, my lord. My seniors are after station.
Your phone
For the petitioner.
on the prayer of Miss B.
B.
Boral and a counsel for the petitioner. This matter stands adjourned. List this case again after the puja vacation. Yes.
I'm obliged.
May I please, your lordship? Lordship, I beg to mention item number 2, lordship. May be
Yes.
listed immediately after vacation, lordship.
Your name, please.
D. Devi, lordship.
Ms. D. Devi, learned counsel for the petitioner. 6. Adjournment in this case with a prayer to list the matter again after vacation. Prayer allowed, list accordingly.
Obliged.
May I please, Lordship. May I
Yes.
please, Lordship. Lordship, I'm praying for listing a matter for admission after vacation, Lordship.
When?
After vacation on 21, Lordship.
Oh, after vacation, we exam 21. Fourth week, last week of October. Yes.
Very late promotion, item 1.
None appears for the petitioner on call. This matter stands passed over for the day. Yes, next.
Item 3.
May I please, your lordship?
Yes.
During this day, my lord, some development has taken place, my lord. Kindly, I may be allowed to withdraw this petition to file a fresh, my lord.
All right, Mr. D. Varwal and counsel for the petitioner submits that after the filing of this writ petition, certain subsequent developments have taken place in the matter, which are required to be brought on record. As such, he seeks leave of this court to withdraw this writ petition with liberty to file a fresh. The prayer is not opposed by Ms. R. Decker, Lane, SC Water Resources Department. In view of the above, the writ petition stands disposed of on withdrawal with liberty as stated.
Obliged, Your Lordship. May I please, Your Lordship?
Yes.
The petitioner's husband was working as a patwari under the office of the Assistant Settlement Officer Udarban Kachar, and he got retired on 31.
Second wife is seeking pension,
Yes,
family pension.
She got married after the death of the first wife.
But Mr. M.R. Sodial and counsel for the petitioner. The petitioner in this case is the second wife of the deceased government employee, namely, what is the
Samsu-
name?
So Safiquddin Majumdar.
Safiquddin Majumdar, who got married to her after the death of the first wife. The petitioner is aggrieved on account of the fact that family pension payable on account of her husband, deceased husband, has not been released in her favor due to non-inclusion of her name in the PPO book. Full stop. Mr. A. Chakravarti, learned government advocate Assam, prays for some time to obtain instruction in the matter. Issue notice returnable in 6 weeks. Since Mr. Chakravarti has appeared and accepted notice for respond numbers 1, 3, and 4, and Mr. B. Chakravarti, learned CGC for respond number 2, service of notice is deemed to be complete in this case. Extra copies of the writ petition be furnished to the learned standing counsel so as to enable them to obtain instruction. Register to list the matter again by reflecting the name of learned counsel for the respondents in the court list.
Deeply obliged.
May I please?
Yes,
Minutes. He was promoted as deputy director, proceeded against an inquiry as deputy director, paid subsistence allowance on that basis,
then started a criminal case where he was convicted and then finally acquitted by this court. Now what they are trying to do, they are trying to, so far the subsistence allowance is concerned, they have downgraded him to get the lower scale. So from deputy director, he becomes a probation officer, and then the direction to the.
Where is the order challenge? Which order?
The lien shifted to probation officer at page 44. He was lent to NC Hills. In the interest of.
What is a substantive post? What is a substantive post?
If your lordship sees 21, he was promoted as deputy director. That your lordships will get at page 21. And he continued as such. And he was prosecuted as deputy director, and initiation of proceeding also on the basis of that. And they were paying subsistence allowance. After his acquittal by the High Court, this shift has taken, he was released and then he is downgraded. And that is something unheard of.
Yes.
Okay, and this is issue notice lordship.
Huh?
Issue notice lordship, obtain the instruction lordship, after a vacation lordship.
So what is your?
My prayer is the subsistence allowance should be as before. It can be, I can't be lowered to a probation officer from deputy director as far as the subsistence allowance is concerned. And that is a prima facie absolutely illegal.
Until the returnable date, you pay the subsistence allowance as per the.
As was done earlier.
Heard Mr. P.J. Goswami, Learned Senior Counsel, registered by Mr.
PJ Dr.
P.J. Datta, Learned Counsel appearing for lead petitioner. Assailing the order dated 3/9/2024. Issued by the respondent number 4, is it?
Yes, ma'am.
Respondent number 4, downgrading the petitioner to the post of probationary officer from deputy director is assailed in this writ petition internally on the ground that by arbitrarily downgrading the petitioner, the respondents are seeking to lower the amount of subsistence allowance paid to him as per the earlier as per the post held by earlier. Full stop. Mr. Goswami submits that the procedure adopted in this case is wholly arbitrary and illegal, and hence deserves to be interfered with by this court. Full stop. Mr. A. Chakravarti, Learned Government Advocate Assam, prays for some time to obtain instruction in the matter. In view of the above, issue notice of motion returnable on any date you want, any
As your lordship, please.
returnable on 30th of October 2000. We'll make it 28th of October, 28th October 2000, October 2010. Since Mr. Who is appearing for whom?
Respondent 1, 2,
Mr.
4,
A. Chakravarti
5,
has accepted notice for respondent number
1, 2, 3, 1, 2, 3, 4, 6, and 7 notes.
1, 2, 3, 4, 6, and 7.
7.
And Miss R. Decker, Learned Standing Counsel, NC Hills Autonomous Council. For respondent number 5, service of notice is deemed to be complete in this case. Extra copies of the writ petition be furnished to the Learned Department Council, requisite in numbers, so as to enable them to obtain instruction. Heard on the prayer of interim relief, the said prayer will be considered on the returnable date. However, having regard to the facts and circumstances of the case, as well as for the ends of justice, it is hereby provided that till the returnable date, subsistence allowance payable to the petitioner shall be at par with what was being received by him prior to the issuance of the impugned order dated 3/9/2024.
Obliged.
Which would, however, be subject to the further order that will be passed in this.
Obliged.
Yes.
There are two schools operating from village and my lord. Now ESI demand has been raised, my lord on the petitioner, my lord, without quantifying the demand, my lord. And my account has been freezed, my lord. We made a representation saying that, my lord,
We want to do it in vacation bench. Today we can't pass any order. We have to give them time. Why have you come now? Last day of the
No, my lord, I just filed earlier, my lord, because some defect I have to withdraw it, my lord.
Maybe, but today we
Then
can
on-
only,
it doesn't mean reopening day, my lord.
huh?
On reopening day.
My lord, I am issuing the question of maintainability, my lord, is an alternative provision for such kind of dispute. And this honorable court from time and again and various other orders, my lord, I'll show it, has been referring such matters to the EI court, my lord, under section 75 of the Employee State Insurance Code, my lord.
My lord, the authorizing pass arbitrarily, my lord, without any quantification, my lord.
Even then, my lord,
Or I will issue notice, you can't stop the
My
court
lord,
from,
once-
you cannot stop the court from issuing notice. We are keeping the maintainability issue open.
My
I'm
lord-
not passing a final order today.
My lord.
What is the problem, Mr.
No,
Smith?
my lord, sorry, my lord. My lord, my objection may be recorded, my lord.
Okay. You are standing counsel
My lord,
for,
Employee State Insurance Corporation.
all right, heard Mr. R.S., Mr. Leonard counsel.
1,
for
2,
the
3, my lord.
writ petitioner. Peruse the averments made in the writ petition. The petitioner is aggrieved by the, what is the demand notice date?
My lord, it is. My lord, 21/10/23, my lord,
21/10,
23, my lord, page 26.
2023, and the subsequent action taken by the branch manager of United Bank of India,
My account is freeze, my lord. They freeze my bank account.
freezing the account of the petitioner. Full stop. Mr. submits that the action initiated against the writ petitioner is wholly arbitrary and illegal. Full stop. Appearing for the ESI authorities, Mr.
M. Smith, my lord.
M. Smith Lanet counsel submits that the writ petition is not maintainable due to availability of alternative remedy. Be that as it may, having regard to the questions raised in the writ petition, this matter in our opinion would call for further consideration. However, in view of the ensuing vacation, puja vacation starting from today, this matter cannot be taken up before 25th of October 2024. As such, issue notice of motion returnable on 25/10/2024. Since Mr. Smith has appeared and accepted notice on behalf of respondent numbers
1, 2, 3, my lord.
1, 2, and 3, no formal notice is required to be sent to the said respondents. Extra copies of the writ petition be furnished to the learned standing counsel, ESI, for obtaining instruction. Petitioner to take steps for service of notice upon respondent numbers 4, 5, and 6, 4 to 7 by registered post with AD within 3 days from today. Hard on the prayer of interim relief, the said prayer will be considered on the returnable date.
But there are two accounts, at least one account may allow to operate, my lord, because my school is stuck, my lord.
You have come on a wrong date, my lord. I've said it already.
But can
You
you
might have, but
not
ex parte is not possible.
of like
Create a matter Passover time being allowed.
Passover will be difficult today. You take one Passover, but the court will rise the moment the matter is over. Yes,
Supplementary list for motion item 24.
one Passover, then we'll shift it. Yes,
Item 25.
Kindly pass out for the time being, my lord.
yes, one Passover only. After that, it's after vacation. Yes,
Item 26.
Please, your lordship, my lord, here I have a very limited prayer, my lord, only to place the case of the petitioner before the SLC, because the DLC has already recommended, my lord, on its meeting dated.
it can't be done now. You are aware of 18/9? No,
Yes, my lord, but
Can't
the
be done.
list has already been
after
prepared.
vacation, just after vacation. We'll discuss it after vacation. You come prepared. Now it is not possible.
Item 27. Item 27.
Yes, who is appearing? One Passover.
Item 28.
When is the next date fixed?
Next week. Not given, my lord. Next day, 27/9 was the date, my lord. Thereafter, no, there has been notified. There are cases which your lordship has.
We'll issue notice, but you need not file written statement till the next date. That's all.
No, my lord, our written statement has been already submitted. Submitted. Before hearing. In the meantime, the search sheet came in.
No, charge sheet in the criminal case.
Criminal case. Same set of witnesses, same set of the.
But you have already taken your defense.
No, my lord, that's the whole, now, the 208, there is similar order. I think your lordship, I have been told
that these type of cases at page 208 kindly be seen, my lord. 208. Only what I am praying on that till the return on the way. See 208. 208, my lord. This is
Yes, who is appearing?
I might. At least issue notice, lordship. Issue notice, lordship. Unable to
Nothing
obtain
more.
any instruction, lordship.
All right, heard Mr. D. Das, Learned Senior Counsel, listed by Mr. D. Gogoi, Learned Counsel for the writ petitioner. Peruse the amendments made in the writ petition. The petitioner has approached this court with a prayer to stay further, suspend further proceedings in the departmental proceeding initiated against it's a lady, is it?
lady.
Against her on the ground that on the same set of facts and based on the same set of witnesses, charge sheet has been submitted against her
Yes.
in a pending criminal proceeding in the form of, do we got PS case number?
Number
In the form of
936, 2016. 936,
give we got PS case number 936 of 2016. First up, by referring to the decision of the Supreme Court in the case of Messrs. Stuns and Toyotesu India Private Limited versus Girish V and others, reported in 2014 3 SCC
Yes.
636, page
Yes.
208 of power, and the similar orders passed by this court in other matters. Mr. Das has prayed for suspension of further proceeding in the departmental inquiry. Full stop. Mr. H. Chakraborty, Learned Counsel for the Learned Government Advocate Assam, has prayed for some time to obtain instruction unit. In view of the above, issue notice of motion returnable on 30th of October 2024. Full stop. Since Mr. Chakraborty has appeared in accepted notice for
All
all
the
the respondents, no formal notice is required to be sent in this case. Extra copy of the writ petition be furnished to the Learned Departmental Council so as to enable them to obtain instruction. Hard on the prayer of interim relief. Mr. Das submits that although the petitioner has submitted a written statement in defense, no further date has been notified in the departmental proceeding. In view of the above and considering the
After 27.
law laid down by the Supreme Court on this subject, as an-
27/9 was the last date.
no further date has been notified in the department.
After 27/9.
After 27/9/2024. Full stop. Now, sir, having regard to the facts and circumstances of the case and the law laid down by the Honorable Supreme Court in the subject. This court is of the opinion that the petitioner would be entitled to ad interim protection pending instructions to be obtained by the Learned Government Advocate Assam. As such, as an ad interim measure, it is hereby provided that further proceeding in the pending departmental proceeding shall remain state till the returnable date. However, the prayer for interim relief made by the petitioner shall be subject to review on the next date.
And the
Review oblique modification on the next date fixed.
May I please, your lordship?
Yes,
Lordship, I am representing for the item number 29 and 30. Lordship, at first, I would like to proceed with the item number 30, lordship.
all right. Yes. What is the prayer?
It's regarding suspension, your lordship. They have challenged the impugn order of suspension, your
So
lordship.
we'll issue notice today. What can be done?
Lordship,
Yes, that's all.
lordship,
All right. May I know your name, please?
NT Manpung, lordship,
NT
Manpung,
Manpong.
lordship.
Right. Item 13, Lego heard Ms. NP Mampung, Direct Counsel for the petitioner, also heard Mr. GJ Bordolo. G.
For
Bordolo,
respond number one,
heard Standing Counsel,
Corporation
Corporation Department.
Respond number one.
For the respond number 1. The petitioner is aggrieved by the order of suspension dated
6/6/2024, lordship.
6/6/2024. And the failure on the part of the respondents to review the same after expiry of 90 days from the issuance of the same. Is that?
lordship.
Lordship,
Mr. Bordole prays for some time to obtain instruction in the matter. Issue notice of motion returnable in 6 weeks, in 4 weeks. Since Mr. Bordole has accepted notice for respondent number 1, no formal notice is required to be sent to the said respondent.
Lordship, otherwise the suspension order has been issued by respondent number 3, Your Lordship. For the notice has to go.
Petitioner to take steps for service of notice upon respondent numbers
2, 3 and 4.
2, 3 and 4 by registered post with AD within 3 days from today. List along with item 29. And what is the date of suspension?
6/6/2024, Lordship.
Here also same day.
No, Your Lordship, two different. That is 3/4/2024, Your Lordship.
Item 29 of the 3/4. Suspension order dated 3/4. No, it is also 6/6.
The first one is 3/4/2024.
3/4,
And the
yeah.
second one, item number 29 is 6/6/2024, Lordship.
It's a item 30,
Annexure 5, page 27, Lordship.
item 30 order date to the above. 3/4/2024.
Other one is
29 of
6/6, Your Lordship.
order date to the above. 6/6/2024. बाकी एक থাকিব सब बाकी सब एक থাকিব
Obliged, Lordship.
list along with item 30.
Pending motion matters, item 10.
Please, my lord.
Yes.
Unfortunately, I had taken time for senior counsel, Mr. Kane Chaudhary, but he couldn't be present, madam. To remove the matter, madam. But basically, I'm aggrieved by the order.
Where is
dated-
Mr. Chaudhary? Where is it?
He's in legs in another court, madam.
Let him come.
My lord.
If he comes before the rising of the court.
Well,
Item 24.
Notice at this stage.
Both of the 24 and 20 are connected.
Heard Mr. P. Chaudhary and counsel for the petitioner peruse the amendments made in the writ petition. Issue notice returnable in 8 weeks. These are private individuals.
Which one? No, contempt.
These are contempt.
Contempt, Your Lordship. These are officer.
Acha.
of the ONGC.
Peruse these statements made in the contempt petition alleging willful disobedience of the order dated.
Award, Your Lordship. That is award dated,
Award passed by whom?
award passed by industrial tribunal, which has been affirmed by this honorable court, affirmed by Apex court. Again, it came again, Your Lordship is aware of the matter also that heinous matter which are there.
Correct, but contempt will lie for violation of this court's order, not labor court's order.
So this court order is also violated, Your Lordship.
Which order?
This the single judge order and the Apex court order also.
What is the date of the order?
Date of order is, I'm just giving you, Lordship. That is 21/5/2004.
2004.
Yes, sir.
We'll have it after vacation. You have come after so many years.
No, Your Honor, this matter, it is going, it was, no, it is not after so many years, because what has happened, Your Lordship, we got, 2019, we have been appointed, and Your Lordship, what has happened?
That is on the merit of the matter.
Yes, Your Lordship.
All I'm asking is,
Yes, sir.
a contempt case would be maintainable
Yes, Your Lordship.
for a violation of this court's order.
Yes, Your Lordship.
If this court's order is passed in 2004, then after
No,
20
that the
years,
Apex court, this court order, subsequent orders are also there, Your Lordship. Subsequent DB's order is also there, Your Lordship. DB's order, Apex court.
argue the case.
Your Lordship.
Argue the case, yes. Which is the order of the court which has been violated? Please show us.
Your Lordship, what I'm saying, Your Lordship, the award directed them to regularize all these employees with effect from 99 itself. Then ONGC came before this honorable court, single judge, they lost it. Division bench, they set aside the single judge order and remanded matter. Against that, 2 unions were there, they went to the Apex court. Apex court set aside division bench judgment, again send it back to the High Court, Your Lordship. Then division bench of this honorable court has decided and dismissed the writ appeal of the ONGC, Your Lordship. Thereafter, they went to the Apex court again, that was also dismissed, Your Lordship. Then subsequently, Your Lordship, after that, they appointed a fresh appointee instead of regularizing their service. So that it is continuing, and they have not regularized also. They have been appointed on probation basis. So that's a clear violation of all these orders, Your Lordship. Not a single order, Your Lordship.
Which order of the court, this court has been violated?
Your Lordship.
Mr. Chaudhary, you have understood the
Yes, I
question.
understand.
Apply your mind.
Yes.
Otherwise, I'll pass an order which will not be palatable to you. This jurisdiction can be invoked only alleging violation of a court's order, that too within 1 year of the order.
But I have annexed article to.
Which order of the court has been violated of this court?
That I check that later.
Show the order.
Order is this one. Your Lordship. This order, if your Lordship will see. The Lordship,
When you want it, give a date after vacation. Convenient date
in the month of November, Your Lordship.
in the month of November. On the request of Mr. P. Joseph and
It
counsel.
will be 18th or so, 18, Your Lordship, 18.
18th. List this case again on 18th of November so as to enable him to examine the legal issues and address the court. Same order in item?
This is separate. This is a writ petition, Your Lordship.
Ah.
Here I am,
Okay.
Your Lordship,
This is item 24.
27.
Yes, next matter.
Yes, 27, Your Lordship, sorry.
27 notice will go.
Yes.
For Mr. P. Chaudhary and counsel for the petitioner. There is the averments made in the writ petition. Issue notice returnable in 8 weeks. Or you want it on 18 November? 18 November 2024. Petitioner takes steps for service of notice upon the.
Yes.
That is.
25.
It is 27, huh? Yes. What is the instruction?
No, chief. The next page is the sanction strength and about. Already occupied by lordship, we have a sanction strength of. Actual authorized strength is 6, but hard scale strength is 4. Out of this 4, 3 are occupied by office superintendent, 1 from the UDC. So if one can be removed, then only he can be accommodated. One
Will
UDC.
stay, it can't help it. You could have done it easily. Unnecessary or.
Lordship, other low medical category.
See,
they
your
are
rule
posted to
says
further-
you cannot place him in a place where the facilities are not there. You have to find a way to comply with your rules.
Lordship, that's true, that
That
OMs
is-
are
that's
not,
true, that's the
lordship,
end of the matter.
OMs are not.
All right.
Enforce any legal right, lordship. Those are only guidelines that can to be, not to be arbitrary, not to act arbitrary, lordship.
Take down. Heard Mr. R. Mazumdar and a counsel for the petition. Also heard Mr. B. Chakraborty and CGC appearing for the respondents. Full stop. The writ petitioner is a personnel serving under the
Border roads.
Border Roads Organization belonging to the low medical category. Full stop. According to the standing circulars of BR, a personnel belonging to the low medical category, bracket LMC, are required to be posted where requisite medical facilities are available. However, the petitioner, who is presently posted at Guwahati, has been transferred to Inkyong, bracket AP, by transfer order dated
10th of August, page 44.
10th of August 2024. Full stop. The counsel for the petitioner submits that his client is ready and willing to serve in any location where the medical facilities are available for the LMC category candidates. However, in Yongkyang, no medical facility is available for LMC category candidates. Hence, he is seeking a modification of his transfer order. Full stop. By taking note of the provisions of the rules as well as the stand of the petitioner's counsel, this court had passed order dated 3/10/2024, granting time to the landed CGC to seek instruction and appraise this court as to whether instead of Inkyong, the petitioner can be posted at any other place which has the requisite medical facilities. Today, when the matter is called up, Mr. Chakraborty submits on instruction that such modification of the transfer order would not be permissible. It would not be possible. Instead,
Only in respect of Pasighat, lordship.
Huh?
Only this instruction is only in respect of Pasighat.
To appraise instruction as to whether the petitioner can be posted at Pasighat, which has the requisite medical facility. However, today when the matter is called up, Mr. Chakravarti submits an instruction that the petitioner cannot be placed at Pasighat since there are other personnel already posted there. Situated thus, and in view of the edict, EDDIC, edict of the rules and the nature of grievance expressed by the petitioner, this court is left with no option but to examine the matter further. As such, issue notice of motion returnable on 23rd of October 2024. Since Mr. Chakravarti has appeared and accepted notice for all the respondents, no formal notice is required to be sent in this case. Extra copy of the writ petition, requisite in numbers be furnished to the learned CGC so as to enable him to obtain instruction and file affidavit. Heard on the prayer of interim relief, having regard to the facts and circumstances of the case as well as the provision contained in the relevant circular guideline relied upon by Mr. Majumdar, it is hereby provided that status quo as regards the petitioner's present posting shall be maintained in the returnable data.
Lordship, pendency not a bar to consider whether
However,
medical
Pendency of
facilities
this
are
case
available.
shall not be a bar for the authorities to consider assigning a posting to the petitioner at any other location which has the requisite medical facility.
Only the word medical facility pertaining to his disability.
Facility pertaining to his disability,
I'm obliged.
pertaining to nature of his disability.
I'm obliged.
Let's order impleadment of party. Item 11.
He was there.
May I please, your lordship? The petitioner wants to implead respondent 8 as respondent 8, accountant general, your lordship. The main matter.
Lordship, I am appearing the respondent number 1, 2, 3, 6 and 7, Lordship.
Mr. Your name, please.
R.A. Mazumdar.
R.A. Mazumdar and counsel for the applicant. This IA has been filed with a prayer to implead the Accountant General AE Assam. That is the opposite party herein as a respondent in the connected writ petition. I have perused the statements made in the IA. Mr. C.S. Hazarika, Learned Government Advocate Assam, and Ms. J. Gogoi,
J. Bora, Lordship.
J. Bora, Learned Standing Counsel, PNRD Department Assam are present and submit that they would not have any objection if the prayer is allowed. In view of the above and considering the ground stated in the application seeking impleadment of the OP, the prayer stands allowed. It is therefore provided that the OP herein shall stand impleaded as respond number 9 in the connected writ petition. Applicant to submit amended cost title in the writ petition within 10 days from today. Register to list the writ petition thereafter for orders. I stand disposed.
Obliged.
Also, I think, respond number 8.
8.
Actually, respond number 8,
Eight.
not 9, 8.
Finding of motion matter item 10.
How many motions are there?
My lord, on same set of charges, disciplinary proceeding, my lord. Otherwise, written statement has been filed. The lordship
The
has.
same order has been.
Yes,
passed.
yes.
Heard Mr. K. Chaudhary and senior counsel listed by Mr. R. Sensual and counsel for the petitioner. Also heard Mr. C.S. Hazarika. When was the last date? When is the next date? Next date. C.S. Hazarika, Learned Government Advocate Assam.
In the disciplinary proceeding.
Uh,
No date is fixed, I am
The
told.
petitioner is facing a disciplinary proceeding in respect of charges which are founded on same set of facts involved in a criminal case wherein charge sheet has been submitted. Charge sheet has been
No, not
submitted.
yet. In the criminal case, charge sheet not yet, my lord.
The criminal case,
But the FIRM charge memo, ditto same.
pertaining to what is the police case number?
Yeah. PCB case number 54, my lord, of 2024. ACB PS case number 554 of
ACB PS
2024.
case number 54 of the 2024. Pertaining to the Court of Special Judge Assam. First up, Mr. Chaudhary submits that although the petitioner has submitted his written statement of defense in the departmental inquiry, yet having regard to the nature of facts and the allegations involved in the matter, unless the departmental proceeding is stayed till disposal of the criminal case, it would cause serious prejudice to the interest of the petitioner. In support of his above argument, Mr. Chaudhary has relied upon the decision of so-and-so, 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 asked Govinda Sharma.
Paul Anthony Miller.
Huh?
Paul Anthony.
One hundred and ten.
GM Tang.
Ah,
GM Tang.
GM Tang, etc. Mr. Chaudhary further submits that after the filing of written statement, no further date
Has been fixed.
has been notified in the departmental proceeding. Stop. Mr. Hazarika, Nana G. Assam prays for some time to seek instruction in the matter. Issue notice returnable on, when is the other matter fixed? When was the other matter?
Item 20 কিমান আছিলে? Item 28 Miller, I'm told.
Mr. D. Das's case, when is it fixed? 30/10/2024. Since Mr. Hazarika has appeared and accepted notice for all the respondents, no formal notice is required to be sent in this case. Extra copies be furnished to the learned department council so as to enable him to obtain instruction. Hard on the prayer of interim relief. The said prayer will be considered on the returnable date. However, having regard to the peculiar facts of the case and for ends of justice, as an ad interim measure, it is hereby provided that the departmental proceeding initiated against the petitioner shall remain suspended till the returnable date. The interim order will be subject to review, modification on the next date fixed, depending on the instruction obtained by the learned government advocate.
For admission, item 12.
Yes.
So in this case, they were supposed to file their affidavit. Lordship, in this matter, they are praying regularization, Lordship, retrospective, with Lordship will allow this sometime. Sometime Lordship will allow. In the meantime, we have already forwarded the affidavit.
And counsel has appeared petitioner, Mr. P. Nayak and Mr. R. Tharan, understanding counsel, finance and PWD Assam have respectively have prayed for 4 weeks further time to obtain instruction and file affidavit. Prayer is allowed, list matter.
Item 13.
13 days, 14.
Please, finally, peruse the order dated 39, my lord. Today fixed for disposal, my lord. It is a covered case.
Disposal will not be possible. Is it covered?
My lord, I have received instruction, my lord. It seems it is covered, my lord. Yes. What I can do is, my lord, I can file an affidavit if required, so my lord.
File an affidavit. Heard Mr. K. R. Padgiri, learned counsel for the petitioner. So heard Mr. R. Dharan, understanding counsel PWD Assam, who submits that he has received written instruction in this case and therefore be permitted time till 28/10/2024 to file affidavit facilitating disposal of the writ petition. Prayer allowed. Mr. P. Nayak, learned SC Finance, and who else is there? Your name, please?
On behalf of Beach.
Mr. B. Chakraborty, learned and standing counsel for AGAND, and Mr.
R.S. Romhan, okay.
Mr. R.S. Rangman for KSC are present. List the matter accordingly.
For order item 14.
May it please, Your Lordship. So if Your Lordship peruses the order of 27 of August, Your Lordship.
What is it? It's not defined. Where are the orders, earlier orders? It's not defined. That's fine.
No, we have received the instruction.
There were 4 issues, Your Lordship, you have mentioned in the order.
Well, issue-wise, reply has come. As far as my figures regarding pendency of cases in the FTs, my lord, the report has been prepared and it has been submitted before Lordship.
Yes, and what are the other issues?
Yes.
Actually, regarding library facility point, issue number 2, Your Lordship.
Issue number 2, the answer is one, the matter has been communicated with the judicial department and the request has been made for the names and list of books, relevant barracks and local law journals to be provided to the members of the Foreign Tribunal. Once the information is received, necessary action will be taken to provide the materials to the members. So they will provide it, subject to the availability of budget provisions. Next is my lord, appointment of government pleader, assistant government pleader for the foreigners tribunals, particularly in the Hailakandi. In this regard, it may be informed that the matter of appointment of assistant government pleader in 9 foreigner tribunals, including FT Hailakandi, is already under process. And apprise the court on the whether government is considering the requirement of imparting refresher course training to the members of the foreign tribunal. A proposal has been received from the so-and-so standing council regarding the advanced training workshop for members and assistant government leaders of foreign tribunals. The proposal is under consideration and discussions have been held with the standing council and necessary steps will be taken accordingly. Well, so far as the first one is concerned.
Yes, please.
Well, so far as the first one is concerned, which is most important here. Since in the last order, your lordship has already mentioned the number of cases disposed of. Now, let the amicus compare about and submit a report about the percentage of cases of disposal. So, based on that, your lordship can take a call.
We have been also provided to the chart, Your Lordship, regarding the number of pending cases before the FTs, Your Lordship.
So you examine this
Yes,
and then you submit your
Yes,
report.
Your
Heard
Lordship, if I'm
Mr.
allowed, Your Lordship, there is another issue from the FT's Chirang, Your Lordship. I'm allowed to place the order.
No, you can't place anything directly before the court. It has to be routed through the registered judiciary.
I found with regard to some building, well, they said to go first to the registry. Well,
it has to, you
let it
cannot
go there.
present any paper.
Small issues bringing before the monitoring court.
Let it be given to the register.
Yes, Your Lordship.
If he considers it appropriate, then it will be set up as per the procedure.
As Your Lordship.
Not like this. Heard Mr. A. Das Namit amicus curiae appearing in this case, Mr. In terms of the order dated 27/8/2024 passed by this court, seeking response of the state with regard to the 4 significant issues mentioned therein. Mr. Majumdar mentioned therein, including the number of cases disposed of by each foreigners tribunal in Assam during the last 6 months. Mr. Majumdar has obtained written instruction and produced the same before this court, including the figures of cases disposed of by each tribunal. I have perused the same. It appears that with regard to all the issues mentioned in the order dated 27/8/2024, some action has been initiated at the departmental level, and therefore the matter would require further verification based on the report to be submitted by the learned amicus curiae in this regard. In view of the above, let this matter be listed again on 25th of November 2024, so as to enable the learned amicus curiae to examine the
25th
response of the government and submit his report. Give the names of all parties who are
Obliged.
etc., registered judicial, everyone. Appearance.
May please, Your Lordship. In this case, newly impleaded respondent number 3 is supposed to file affidavit, Lordship, in this.
Yes, who is appearing for newly implemented respondent number 3?
Lordship, I am for respondent number 1 and 2, Lordship.
Has notice been served?
Yes, Lordship. Miss A. Gayan appearing, Lordship. She filed a follow-up number, Lordship.
No, but name has not been shown in the cause list.
She knows, yesterday I talked with her.
That's okay.
Sometime
It
may be
is
granted. Lordship.
personal chattings, you do it.
She
We have-
is
I'm for respondent number 3 also.
Yes.
Lordship. Some time may be granted to file a reply,
The
Lordship.
learned counsel for the respondents, including the newly implemented respondent number 3, has appeared and prayed for some time to obtain instruction and file affidavit. Prayer is allowed on the request of Miss Bhattacharya, learned counsel for the learned counsel for the petitioner. Let this matter be listed again in the first week of November 2024 by reflecting the name of respondents counsel in the court list. Affidavit be filed in the meantime.
Item 17 and 18.
Item 17 is a contempt matter. Lordship, last date, impleadment of the new parties has taken place and accordingly amended cost schedule has also been filed. Lordship, the operative, if I may, Lordship, the operative part of the order starts from page 12 is the order passed by my lords, and the operating part is on page 14. This was regarding the date of superannuation, lords.
What is the, where is the order of the court?
Page 14 is the operative part, my lords, of the contempt petition. In view of the above, if I may.
Yes.
Lordship, we have received instructions. We'll file an affidavit immediately, Lordship. It
But
took
why
some
have you
time.
not complied with the court's order?
Because there's certain discrepancies with the petitioner's date of birth, Lordship. We want to
But
bring it on.
accepted whatever you have given. You said it is 31/3/2023 date of retirement. He has accepted that. Is it not? So let them come to the court, your clients.
Lordship, last
No,
opportunity.
Last
may be
opportunity. You are
given.
taking the court very lightly. Why you have not complied with the order of the court?
There's because of those discrepancies, Lordship, we had asked for some corrected papers from the petitioner, which has not been
Where?
received.
Show me the letter. Where? By which letter you have asked?
There's a set of instruction.
Lordship, there's another
You
communication.
please take your seat. Where is the letter you have issued to him asking for correction and certain instructions?
That, Lordship, it's. A speaking order was issued, Lordship. A copy was given to the.
Your officers are coming. We'll pass an order. We'll figure to. Today is the last day vacation, so we'll fix it on. But we'll have your officers present in the court. Huh? Let them answer. They are playing around with the court's order.
Lordship, just one opportunity. We'll
One
place
opportunity
everything
for
in
what?
for our affidavit, Lordship. We would like to place the issues.
No, affidavit means have you preferred any appeal against the order?
We have not, Lordship,
Then
but
you have to comply with the order.
we are willing to, Lordship. Just
You don't have any option. You're bound to.
Lordship.
Not question of willing. It's not your option. We'll make sure that you comply the court's order. Who are you to say you're willing? Your willingness has nothing to do with it. When the court passes an order and the order remains unaltered, you are bound to comply with. And we'll ensure and we'll make sure that you comply with the order. Heard Mr.
J. Singh, Lordship.
Sorry?
J. Singh, Lordship.
J. Singh, Learned Counsel for the petition. Also heard Mr. I. Bothakur, Learned Counsel appearing for the respond numbers.
1, 2, 3, Lordship.
1, 2, and 3.
I'm for rest, for my.
Mr. R. K. Talukdar, Learned Counsel has appeared for the respond number 3.
In this case, Lordship, they have to forward the pension proposal, Lordship. That is why, Lordship, we are unable to say.
The order dated 28/7/2023 has not been complied with till today, and there is no reasonable explanation from the Learned Counsel for the respond numbers 1, 2, and 3 for not doing so. Mr. Talukdar, Learned Counsel for the respond number 4 submits that since the office of the AG A&E has not received any paper from the department, no further action could be taken in the matter. After going through the materials available on record and hearing the submissions made by the Learned Counsel for the respond numbers 1, 2, and 3, this court is prima facie of the opinion that the departmental authorities have acted in utter disregard to the order of this court and has set over the matter without any just and reasonable explanation. Therefore, it prima facie appears that the respondent numbers 1, 2, and 3 are guilty of contempt of this court. First off, however, and therefore are liable to be proceeded against. First off, although this court was inclined to issue a direction for personal appearance of the respondent numbers 1, 2, and 3 for passing further orders in this case, yet taking note of the request made by Mr. Bothakur, learned counsel, appearing for the said respondents, this matter is directed to be listed again on 24th of October 2024 as fixed item for further orders.
Obliged.
Item 19.
Obliged.
May I please your lordship? Lordship, we have received instruction from the petitioner that the respondent authority has complied with the order.
Your name, please?
I hope your lordship. Mr. I hope your lordship.
Mr. So-and-so, learned counsel for the petitioner submits that order of the court has been complied with, and therefore the contempt case can be closed. Mr. A. Chalio, learned counsel, is present for the
Respondent number 2, Lordship.
respondent number 2. In view of the submission made by the petitioner's counsel, this contempt case stands closed.
Item 20.
Obliged.
Yes.
May I
Yes.
please your lordship?
Ah,
Lordship, my senior is out of
on the
state.
prayer of petitioner's counsel, this matter is still adjourned for 3 weeks.
Item 21.
The same Devi, learned counsel is present.
On behalf of Mr. Deenath, respondent number 1.
Respondent number 1, yes.
May I please, madam? Well, when we had filed the writ petition, we are all tax collectors in the panchayat and we were praying for a promotional avenue to the post of secretary. At that point of time, notice was issued in the month of July. No affidavits come from the respondents. As of today, they have made an advertisement and held a recruitment selection process where out of the 1091 post of secretaries available, we have an apprehension that they have on the RTI, they have advertised around 994 posts. Therefore, the entire writ petition will become infructuous if we are not granted some sort of protection, my lord. Otherwise, we don't have post to fight for the promotion.
What protection you are seeking?
My lord, either they may not come up before this honorable court with the number of posts they have advertised and that there's some avenue for us left, or my lord, the selection process, they would not make appointments without leave of the court. Otherwise, everything goes for us, my lord. They proceed. There'll be a direct recruitment. We don't doubt it. But if the entire posts are taken up, where do we stand, my lord? The writ would become infructuous otherwise.
Yeah, who is appearing?
Your lordship, here in this writ petition, I am appearing for all the respondent, your lordship. Here, your lordship, the necessary party has not been impleaded, your lordship.
Who is the necessary?
Necessary party, your lordship, the state level recruitment commission for class 3 post.
That is only the person will
No, we
recruit.
will not stay the recruitment process. We'll stay the appointment process.
Your lordship.
In the second item, I have been impleaded and copy has been served in the item number 21. Lordship, I have not been served any copy, neither of the IA or the writ petition.
So when is the recruitment, when is the examination?
The examination gone last
Exams are
Sunday.
completed, your lordship.
Class 3, on 2 phases, on last was held on 29th of September. It has been completed. Class 4 is yet to start, Lordship. That's the
We are class 3. We go from
Class
4
3
to
already completed on
They,
29th September.
the written exam is completed. The viva is yet to be
This
held.
is for recruitment.
Yes, they are going for a direct recruitment to the posts where we have prayed for a promotion because we don't have a promotional avenue otherwise. Earlier occasions, under orders of this court, people have been promoted to that post. Now they are not keeping anything for us promotion. There is no rules. We just want that they declare either we get promoted or not promoted. Something has to come from them.
In both the cases, you are belonging to class 3?
We belong to the class 3 tax collectors. We want to go from tax collectors to secretaries of the Gram Panchayat.
But both are class 3 post, your lordship.
Yes. But it's a higher post. Ground secretary is a higher post, and persons have been promoted under orders of this court on earlier occasions. On the grounds that we are now.
All right, heard Mr. R. Majumdar, learned
May-
counsel appearing for the applicant, yes?
Your lordship, from the Principal Act, Assam Panchayat Act 1994, section 30 and section 141, he speaks about direct recruitment of GP secretary.
You go ahead with direct, but promotional posts will not be filled up.
Yes.
Your
That
lordship,
cannot wait.
dear lordship, the Principal Act doesn't speak about promotional.
All right, heard Mr. R. Majumdar, learned counsel for the applicant, also heard Mr.
K. Kumar, Your
K.
Lordship.
Kumar Leonard, you are appearing as additional AG. Are you additional AG?
Your Lordship, here, Your Lordship.
Are you additional AG?
Yes, yes, yes.
Say that first.
Yes.
Yes. What do you have to say?
Your Lordship, in the first item, I am appearing as additional AG.
All right. Also heard Mr. K. Kumar Leonard, additional AG Assam appearing for the respondent numbers.
For all the respondents.
All the respondents.
Lordship in the 3601,
No, I'm talking about 3117.
3725.
In that case, no copy
Alright.
has been subbed out for state level recruitment commission.
The applicants herein are presently serving as tax collectors under the various Gaon Panchayats, which is a class 3 category post. According to the applicants, they are entitled to be considered for promotion to the post of secretaries of Gaon Panchayat as per the relevant rules. However, contending that the authorities are seeking to fill up even the promotional posts by way of direct recruitment, the petitioners had approached this court by filing the connected writ petition being WPC number 3725 of 2024. Mr. Majumdar submits that during the pendency of the writ petition, the government has conducted recruitment drive for direct recruitment of candidates to fill up the class 3 category posts coming under the Gaon Panchayats. Therefore, apprehending that the promotional post may also be filled up by way of direct recruitment, the instant IA has been filed. Mr. Kumar prays for some time to obtain instruction and file affidavit. In view of the above, let this IA be listed again for orders on 30th of June, 30th of September, 29th of October 2024. The prayer for interim relief will be considered on the returnable date. However, by way of an ad interim measure, it is provided that the promotional posts in the grade 3 category under the Gaon Panchayat, if any, earmarked under the relevant rules, shall not be filled up by way of direct recruitment without obtaining the leave of the court. This is item 21. And about 22, you write 22, all grade 4.
Yeah, see, no, grade 3, my lord, see, the same. To the post of secretary panchayat.
Acha. Great. Next matter, any naam to dibo? Mr. Kumar for respond numbers.
Except the selection board, Your Lordship, I am appearing for all.
Please tell me the name of the opposite.
Your Lordship, the
1, 2, 3, and 4.
1, 2, 3, and 4.
1, 2, 3, and 4. And
Your Lordship, so far as the 4 is concerned, there is no such post in the PNRD, Your Lordship. Director of Panchayat, there is no such
All right,
post.
1, 2, and 3, and Mr. B. Chaudhary, and counsel for respond number 5. Mr. Chaudhary submits that no copy of the IA has been served upon him till date. Be that as it may. At I said same, rest will be same. You fill up the post direct recruitment, no problem. Promotional post in any case you cannot fill up. You cannot fill up even if you want.
That doesn't come within our MP.
That's it.
Obliged, Your Lordship.
Rest the part will be same, huh? Second. Yes.
May I please your lordship? Lordship, this IA has been preferred to keep a post of this IA has been preferred, your lordship, to keep a post of motor vehicle inspector vacant, lordship, in the disposal of the writ petition.
Find your objection. Heard Ms.
Lordship.
G. Boral and counsel for the applicant, also heard Ms. M. D. Boral and standing counsel transport
For
department.
1 and 2.
Huh?
For 1 and 2, my lord.
Appearing
Lordship,
for
kindly
respond
fix the
number
matter
one.
immediately after vacation, your
Yes.
lordship.
To 3 weeks time to obtain instruction and file affidavit. In view of the urgency expressed by Ms. Boral, let this matter be listed again on 25th October.
Lordship, oblige, my lord. Lordship, can it be on 24th, my lord?
24th.
WPC 2729/19 and analogous practice.
So the broad nature of our judgment is that they have held that the cutoff date of 1/1/2006, which was started by the Act of 2011. That act, when it was under challenge, that provision has not been specifically assigned. And the court has also not given any observation. So Act of 2011 has been repealed. Many venture institutions have been provincialized with that cutoff. So that aspect cannot be reopened to this proceeding. Number two, we have found that section 3(1)(1), the Act of 2017 and the amended provision are violative of fundamental rights of those venture institutions who have been denied provincialization only because there was a late receipt of approval. We have read down this provision. These people cannot be denied. Their claims have to be put to scrutiny committee, and if it is found that they are genuine claims, they will have to be given. So we have tracked the history of development of the educational system right from the British era. We made an attempt to give some statements. And we found that, all right, now insofar as the claim of the tutors to a regular pay scale is concerned, they have accepted that, said that they are entitled to equality of treatment. Because they may not be entitled to equal pay, they are entitled to equal treatment under the law. When other government servants are getting regular pay scale, they will also have to be given regular pay. And the state can do that by framing rules under section 23. It says that the state has to frame rules deciding the emoluments, etc., terms and conditions of tutors. So, consistent with the provisions of the statute, rules have been directed to be framed where they have to be given regular pay scale as other employees. What will be the quantum? That is not our concern. Whatever be the quantum, it could be equivalent to what they are doing or here and there. We are not going to comment. That's not the subject matter of this issue. But they are entitled to equal treatment because they are also government servants. Other provisions, the challenges all have been rejected. So we have upheld the Act of 2017, as well as the Act of 18. By reading down the provision and by observing that the tutors are entitled to this benefit. Other provisions, we have given our elaborate reason why the court cannot go into this matter. Even though this may sound reasonable, unreasonable, rational, court cannot go into this, and the acts of 1977, 1974, all these acts have consistently provided criteria for provincialization, pupil-teacher ratio, qualification, come up to the 2009 Act. Supreme Court has observed that it is a valid criteria. Realm of policy, no scope for the High Court. We said that the courts will have to be sapient and conscious about the context.
I only appreciate that the judgment has been delivered in a reasonable good time.
Please examine it. We have tried our level best to do justice, to balance.
For now, my lord, I am saying this. Reasonable, in a reasonable time
But
frame.
in a plenary statute, the research I could do, I spent several nights not sleeping for these judges.
Obviously.
The hands are very, very tight. Very, very tight. Plenary Act, statute, challenge, very, very tight area. The courts cannot very casually strike down these and say that enacted in this way. They have said that some of the provisions may be very harsh, onerous, even sound to be rational, but unreasonableness, irrationality, these are not even principles of natural justice violation. They are not grounds to set aside a statute. These may be grounds to review a administrative action. So, and this class legislation, we have observed that how can you retrospectively stop mushrooming of institutions? There is no rational behind this. How can you stop the mushrooming growth of venture institutions with retrospective effect from 1/1/2000? But the problem is that statute is gone. Nobody has challenged that. That aspect of the matter is now frozen. This court cannot reopen it in these proceedings because that statute is no longer alive. And the 2017 Act really continues that insertion. So here also we found our hands are tied. Can't do anything about it. There is not even a whisper in the earlier judgment that P1 insertion of 116 has either been challenged or is irrational. That has been accepted, that has been given effect. The act is repealed, it has been effaced. You cannot strike down or declare a effaced law to be legal or illegal. It's the principle. So therefore, to our best of ability, we tried to go into these matters. We examine the judgments, find it acceptable. We'll be glad.
All right, all right.